Hi everybody, my name's Hannah Mollison. I'm the Commercial Director here at Orange Genie. Thank you very much everyone for taking the time to join us today on this Keep Calm, It's Only Recruitment GDPR webinar. It's just going to be a short 30-minute webinar just to give you a bit of an overview of data protection within recruitment companies and also within HR departments. So just to give you a bit of background on Orange Genie, we provide payroll and accountancy services for contractors, and a majority of our clients are recruitment companies. So we thought that this webinar and this partnership would be a really helpful thing to put on for all of our clients and some of DPAS's clients. And I will pass you over to Melanie Garnett from DPAS now.
Hi everybody, thanks for joining us. So some of you may know us, some of you may not. We're the Data Privacy Advisory Service and we deal with data protection consultancy and training internationally and throughout the UK. Just a couple of housekeeping items before we start. Please keep your cameras off. We will be recording this webinar. And we will send out the recording post the webinar for anyone that didn't manage to make it, or if you want to share it with any other employees. Please remain on mute throughout, and if you've got any questions at all, just pop them into the chat box. We will not have time to answer them, unfortunately, but we will send an FAQ out after the webinar to anybody who asks. We'll also be sending a little survey out post the webinar as well. So keep an eye out for your emails this afternoon. So we do ask that if you could fill that in, and it helps us to make better free webinars in the future. So I'll just hand over to Bilal. Bilal is one of our lovely data protection trainers. He runs some of our training courses here at DPAS in freedom of information, data protection, recruitment, and Bilal will continue. Bilal?
Thank you. Welcome everyone. We're going to try and talk about data protection, GDPR, for the next half hour in relation to recruitment and HR and the kind of things that you need to think about. Certainly when GDPR was announced, then it was all going to be doom and gloom. It was all going to be a big apocalypse, the end of the world, the panic, the fines. We were all going to be in trouble. The actuality is that none of that really happened, although it has to be said that some of it kind of did in some respects. So some bad, scary things did happen, and we'll have a look at some of those now. So our own regulator, the Information Commissioner's Office, the ICO, levied, issued a decision notice against First Choice Selection Services Limited, which is a recruitment company. They received a data subject access request, which is where someone wanted a copy of their own personal data. And they essentially failed to provide this without undue delay. In the end, the complaint to the Information Commissioner's Office, the ICO, was upheld, and they have publicly issued a notice against First Choice. Looking around the world, still within the kind of HR recruitment area, the Icelandic service. Now, why are we looking as far afield as Iceland? Well, partly because although Brexit has happened, although we have diverged away from the essence of GDPR, our own Data Protection Act puts the general data protection regulations into UK law. So a lot of these decisions that are going to happen across Europe will influence the way in which our regulator and subsequently our courts will look at data protection compliance. And in this case, the Icelandic Supervisory Authority, which is their equivalent of the ICO, issued a decision notice on the disclosure of personal data to a third party in the context of a recruitment process. Now, the complaint in this case was rejected. However, if somebody gets sufficiently annoyed to make a complaint about you sharing their data during a recruitment process, one thing that has probably failed here, and when I read the decision, it was very, very clear that what had failed was that the recruitment company had failed to communicate the amount of data sharing they were going to have to do. Now, when you onboard people, you have to share data. Sometimes that might be around references, it might be around other kinds of verifications. That has to happen. It's not like that can stop, or whether that should. The real key here is that it wasn't communicated clearly enough. So they showed that it was communicated just legally enough to be okay. However, the organization was mired in a complaint which presumably lasted for months just because they weren't clear enough. In this case, H&M was fined a eye-watering 35 million euros for processing data concerning the private lives of employees, making them available to up to 50 managers and making employment-related decisions on these data. Now, our managers clearly need to know something about us. So for example, if I'm working somewhere and I, for example, have caring responsibilities, if I have health issues, or if there are all sorts of other things, I might need to share those things with my boss so that they can make adjustments for me, so they can manage me properly. And it might be something as simple as I need to go on a school run in the morning, and they will need to know that. But is that if they've made the stuff available to up to 50 managers, and they made incredibly inappropriate things available to those 50 managers, and those 50 managers then use that data not just to manage their employees, but just to go, right, that person there is not going to get a promotion because, you know what, they've got caring responsibilities and we're not sure we can rely on them. That kind of thing. So the idea here again is not that managers cannot have access to information about appropriate, relevant parts of the private life of their employees, but only those which the employee is perfectly happy to hand over, and they should only use it for their employment purposes, not to make employment-related decisions that are inappropriate based on that data. So it's right that my boss goes, right, Bilal needs a slightly more flexible working hours because he has his caring responsibility, but it's not appropriate for 50 managers to know this, and other managers go, oh, well, let's not give him a promotion because, well, you know, he seems to be busy doing other things. In this case, a controller in Finland was fined 12,500 euros for collecting data during job application processes that was not directly necessary for the employment relationship. Now, when you are applying a job, quite often I have seen this, people will ask, for example, for my national insurance number. And I think to myself, why do you need that at this stage? I'm applying for this job. You do need to know that I have a national insurance number. By all means, ask me to tick a box saying, have you got one? You can by all means say, are you eligible to work in this country? And you may even then say, how are you eligible to work in this country? Do you have UK passport? Do you have this work permit, etc., etc.? Do they need my national insurance number? Clearly at the point at which I am being interviewed, that is not needed. That is needed afterwards. So quite often, a lot of application forms are very, very, very data hungry. They ask for information that is not necessary. And if it's not necessary for the employment relationship, this will become a breach of the Data Protection Act. In this case, although this one, we could do an entire day just on this one case, 100,000 employees of Morrison's had all of their data being held by Morrison's. A contractor was brought in to work with HR. He stole all their data and published it. The employees and the case was settled in a very, very, very complicated way. Contractors that work for you, you have a responsibility towards them, because in this case, it would have cost them a lot of money. It would have cost them probably a couple of £100,000 to defend this kind of case. So GDPR and data protection, I'm kind of using them slightly interchangeably because a lot of people as being the big scary monster, and data protection, it sounds like this other thing. GDPR was the European Union agreed regulation, and the Data Protection Act put it into force. And what did it do? Well, the main things that it did, it was an evolution in the use of data, respect for individuals, understanding what happens with data, and documenting your actions. And out of all of those, the most important one is respect for individuals. That is what this is about. And while organizations talk about respecting individuals, quite a lot of them are not actually terribly good at doing this. So let's try and figure out why we should do this kind of thing. Now, the biggest problem around data protection is reputational harm. So, for example, let's take the extreme case, Morrison, 100,000 employees. Imagine having 100,000 employees' data stolen. You now have an intensely unhappy workforce the next day. That is something that no employer can absolutely contend with. You will harm your relationship with your client companies. So if you are a recruitment agent, you will harm them with your client companies. You will harm your relationships with your candidates. If you're a recruitment company, harming your relationship with any client companies that you have, any organizations where you might put placements in, is problematic for you if you have data protection breaches. Now, behind it's not just about the fines. Behind every single fine, there is a massive cost to fix things for the regulator. Let me give you an example. So I worked with a client once, and they did terribly stupid things with data, and I was called in to try and come in and tidy it all up. Part of this had two consequences for them. The fine was very, very little. It was very, very, very little, and the fine didn't really matter. What mattered was that the companies and organizations they worked with walked away. They didn't want to know. When they were doing due diligence on them and said, like, can we have a look at your summary of your accounts? Can we see who your previous clients are? Can we look at all this other stuff to prove how great you are? One of the questions that is often asked is whether you have had a data breach or not. And if you have, and it's made public through the ICO's website, and they publish all of these, your clients start walking away. They have no real reason to work with you at that point. They just lose confidence in you. This is particularly important if you're a recruitment company, because getting onto the preferred suppliers list, the PSL, for a public sector organization can be a really lucrative thing to do. And public sector organizations are very, very, very hot on asking this question: have you had a data breach? If you have, they are unlikely to start working with you. The other problem you often have is that while the fines may not be very much, the regulator will often say, you've done this bad thing, you didn't have the systems to do this thing right, can you please go away and fix it? I have worked regularly in organizations where their fine was either zero or very, very, very little, but the bill to fix stuff in the background, because the ICO would typically give them 12 months or 18 months to go and fix a bunch of stuff, could easily be £1 million, £2 million. That's the problem. You now have to bring in project managers, data protection specialists, data specialists, security specialists, lots and lots of IT people, and they have to come in and start fixing your systems in a really, really, really quick way. And suddenly your budgets really, really go, they just tank. So these are the reasons why we should do data protection if respect for individuals isn't enough, because it can be incredibly harmful to organizations not to do it. When you work in and around recruitment, you have basic relationships with certain kinds of stakeholders. So you at the center, you might have candidates seeking work, and you have candidates in roles. You might have client organizations. And again, if you're working within HR, you have kind of the same thing. You're dealing with people, and so there are people who are applying for jobs, and there are people that you've placed. There are also recruitment companies that you are dealing with. There are jobs boards out there, and the jobs boards that are out there have weird and wonderful terms and conditions. It's not entirely obvious how it is that they can scrape your website and dump your vacancy onto their board. Sometimes they do that, sometimes you have to pay them to do that, but all of their terms and conditions are weird and wonderful. The last one, which is the most interesting one, is you all have suppliers. Now, your suppliers could be anyone from Office 365. Every system, every piece of software you use, every piece of hardware you use, the cloud where all of your stuff is held, down to the, if you still have them, filing boxes where stuff is held and you say this is held securely. All of these are suppliers. And certainly as we become more and more IT heavy, your IT suppliers get to manage and hold and process personal data for you. You have to have an understanding of where that data goes, how it is that you're sure that they're making fair use of it, how it is that you know that they're looking after it. So what do you have to do? You've got to comply with two basic things. So it's a UK Data Protection Act 2018, and that's what brings the General Data Protection Act into UK law. And the other one is the Privacy Electronic Communications Regulations. This is, it's quite long and quite involved, but there is a section that deals with marketing emails. And of course, marketing emails, very, very important component of recruitment. So the Data Protection Act says 8 basic things. There are a bunch of principles that you have to comply with. And the first one is you have to be lawful, fair, and transparent. You have to limit your purposes. You cannot reuse information for a completely different reason. So if, for example, Orange Genie and DPAS have collected your email addresses in order to register you for this webinar, if they then go, oh, why don't we go off and use all of this and sell this to a double glazing company, why can they not do it? The reason they cannot do it is because the purpose for which they can use this data is limited, and they must use it for the purpose for which they collected it. And where is that purpose defined? It'll be defined in the registration form. You must minimize data. You can't collect too much. If I am, for example, checking into a hotel, they can certainly ask for my name, they can ask for my address, they can ask for other things that identify me and make sure they can bill me. They can't ask me my sexuality. It's not relevant. They may be entirely fascinated by this, but they can't have it. You should only ask for data that is necessary. You should minimize the amount of data that you're asking for. Information has to be accurate, and we absolutely know this because you know, we have lots and lots of terrible things happen when data isn't accurate. Your credit report is not accurate. It claims that you paid off a credit card bill late, and a year later you still can't get a mortgage. These are the real world effects of information not being accurate. You must limit your storage. You must not hold on to information for too long. What is too long? Well, a lot of what is too long is set out in legislation. So there may be bits of employment law saying you must keep a personal record for this much amount of time. Certainly things that are being used for taxes, etc., need to be kept for much, much longer. But other things such as someone applies for a job, they do not get the job, how long should you keep it for? Well, there is equality law that tells you that you should keep it for 6 months, because 6 months is the amount of time that someone can appeal that you did not make a reasonable adjustment for them, and after that you should delete that application. Now, obviously, a lot of the time we hang on to those applications. How can we hang on to that application? By telling people, hey, other roles might come up like this, and I've done this. I've recruited, and I've said to people, we thought you were a great candidate. We want to hang on to your application for 3 years because we think another role like this might come up. Are you cool with us doing that? And they go, yes, and I go, fantastic, and I hang on to it for much longer. It's not a big deal. Otherwise, if you are directly recruiting in, then maybe you should only keep it for 6 months, because that's what the law tells you. So part of it is law, the other half of it is business need. So you should have clearly defined business needs, and it must be necessary for those business needs. So again, there's this idea that you can't just decide, oh, well, it would be convenient, it'd be nice. There has to be a great urgent business need for you to keep something, otherwise it should be deleted. Security, of course, enormous issue. Making sure that only the right people have access to information. So HR departments incredibly well. It's very, very obvious that your HR records should be kept confidentially. So even in buildings where the offices are open plan, we know that HR often have their own room. Why? So that somebody walking by from from a completely different business unit can't just start rifling through or oversee or overhear something that's about another member of staff. That applies to your emails. It applies to all those times when you say to someone, can you please send me a scan of your passport? How does one know that the passport image is being received securely? So all of that stuff is all around security. Accountability, which is a new thing in GDPR and therefore now in our Data Protection Act, you have to prove that you are complying with the previous 6 principles. So you have to have documentation to show all of this. And then the last bit that often leads people into problems are people's rights. The most common right people assert is the subject access right. That's a right that I have to ask for a copy of my information if you hold it. And there are statutory deadlines around answering that. So in relation to these kind of stakeholders that we have, fair, lawful, and transparent, how do we do this? I mean, this is going to be a bit of a whistle-stop tour. A lot of these things require just a lot more detail. When someone is seeking work, tell them what you are doing with their data. Be sure you can ask them about their skills and history and understand the lawful basis for it. When a candidate is in a role, be clear about what you're going to tell employers. Be clear about how you are going to exchange information about sickness and discipline issues. Client organizations, tell them what you're going to do with their data. Put a privacy notice up on your website. Tell them how it is you're going to manage their data. When you're looking at a jobs board, how are you allowed to scrape LinkedIn? How are you allowed to scrape other boards? How do you tell people about it? So I go onto LinkedIn because I'm looking for a PhD in psychoanalysis, and I go and I find these people and I scrape all their details off it. How do I tell those people that I'm scraping their information off this? Well, how do I make it transparent to that person? These are all great challenges. When it comes to suppliers, know where they are and what they will do with their data, and tell people. Your privacy notice should say, we use Microsoft Office 365, for example. It does this, and this with your data, etc. That is how one is transparent. Limiting purpose. I signed up once to a payroll company for a contract, and they then shared my data with all sorts of other organizations who all came and started marketing to me. You can't share with partner organizations such as other umbrella bodies, etc., without consent unless it is necessary for the contract. If it is necessary for the contract that you share my data with people whom you're asking references, you're sharing with potential employers, that is necessary for the contract. Is it necessary for me to be employed for you to be selling my data on to other third parties? No, you can't do it. It's not necessary for the contract. You cannot start selling my data like that. When someone is in a role, it is the same thing. You just cannot start selling data all over the place. You're limiting your purpose where you don't use the data from client companies, client organizations for any other thing. You minimize data. When do you need that proof of ID? Do you need it at the registration stage? Do you need it at the signed contract stage? Why do I need to know things about you? What do I need to know in order to assess whether you are suitable for this contract or not? If you're if you then get to a stage where somebody is about to come into a role, how many years of references do you really need? I've been asked for references going back 10 years, and I just thought, God, I don't even remember who I worked for 10 years ago. And they've all kind of moved on, and it's become impossible. Do you really need 10 years worth? Is that relevant? Where did that come up from? Collect as little data as possible. Doesn't mean collect nothing. You must collect the right amount. You must collect what is necessary. Right? It never says collect too little and cause yourself problems. It says collect as little as possible. You have to make sure your data is accurate. you have to limit how much time you store information for. If you hold data for candidates in roles or seeking work, or for organizations, tell them how long you're going to keep that data for and have a reason for it. Either a legal reason for it, so we keep the stuff for 6 years for insurance purposes, or it might well be we have a business need to keep this. This is why we have to keep this. Tell people about that. Security, absolutely key. Your communications, your storage, your sharing, all of that has to be secure. And that's not just about encrypting stuff, it's about making sure that the right people have it. And HR teams are very, very good at this. They make sure that only other people in HR can see HR data. Managers are assigned roles, so my manager can see my sick leave, but the chief executive can't see my sick leave. Why? Because they have no reason to. It's my manager that can see it. Maybe my manager's manager can see it in case my manager is off sick themselves, but that would be where it would stop. You grade access for people. You keep information confidential. Accountability. When it comes to contracts, you have to have clear agreement with data protection clauses, setting out what is expected. To get onto, again, the magic preferred supplier list, you often need to do a huge amount of other data protection work, like putting together record of processing activities, show that you have policies, show evidence that you adhere to the Data Protection Act. That is one of the key issues in getting onto PSLs, and I've done this many times for, well, at least for 5 recruitment companies that I can think of, where they've said we're trying to get onto the PSL, they need a bunch of documentation, can you work with us for and create it? And I've gone, yes, I can, and I've worked with them, created a whole bunch of stuff, and it was done. Suppliers, you have to do due diligence on people. The data goes. You have to have clear contracts with clauses around. You have to know where the breach is and what happens when you exit a relationship. You have to have a clear understanding of data they will delete, what they will hand back, how they will hand it back, when they will hand it back. You have to have a good look at what they are doing with the data that you are going to entrust them with. Right, now this is a place where people often come across. People will ask for copies of their own information. That is the most common, the data subject access right. There are other rights, the right to be forgotten, the right to erasure, etc., etc. Those don't come up very often. But on the ICO website, for example, you can just go and find a list of data subject rights. And what is key is that no one has to write in saying this is a data protection request. If I write in, say, can I please have a copy of my data, I should be able to write into any organization that has it, and they should go, aha, hang on, that's a subject access request. I must pass that on to somebody who understands what it is. So it's really key that all of your staff are trained to recognize them, albeit that only maybe one staff or maybe no staff, and you outsource it, are actually able to comply with the request, are able to fulfill it. But it's very important that people are able to recognize these requests. The other piece of legislation that you have to comply with is PECA, the Privacy and Electronic Communications Regulations. You can't email an individual with a marketing message unless you either have consent, where they've clearly unambiguously said, yes, please send this to me, or if you are a private company, this does not apply to public authorities, you have a soft opt-in. You can email a business, so if it's info@acme.com, you can email them without consent, etc., with a marketing message, but you have to offer an opt-out. Marketing is defined in this very interesting way: the communication by whatever means of advertising or marketing materials which is directed to particular individuals. So when I put up a billboard, I'm not marketing it, I'm not directing it to particular individuals, but emails are to particular individuals. You are advertising something to highlight a product or service, which is clearly what we do most of the time. You can use a soft opt-in. What is a soft opt-in? Again, this is all a bit whistle stop, but when someone engages with you, you can engage with them to market similar products without consent. You can do it using the soft opt-in. So if a candidate clicks on the job and hits apply, but then abandons the application, you can send reminders by email or similar things. Next steps, look at your processes, starting with security, public-facing transparency or privacy notices. That's where I would have a start. And if you want to know more, we have a half day of data protection and recruitment on the 29th of November. The details will be sent to you along with the survey, and you can get 20% off by using the discount code. So DPAS offers all sorts of other services, DPO as a service, ROPA, audit policies, critically SAR support, which is incredibly popular. Thank you for attending. Apologies, whistle stop, but I hope to see some of you at the longer session. If you have any questions, please do put them in to the chat box. We'll collate them, try and send out answers to FAQs in the next few days. And great thanks again to Orange Genie and to DPAS for hosting this.